Now the taxpayer contended that it is practically not possible. So they challenged the provision of Rule 39 itself, which to the extent it requires the distribution in the same month. So the Honorable High Court observed that the Rule 39 is not invalid. The Rule 39 is legal. They upheld the rules. However, they specifically observed that Rule 39 requires ITC available for distribution to be distributed in the same month. So they said that this this has to be interpreted that only when the conditions of section 16(2) are fulfilled, all the conditions, then only the ITC becomes eligible for distribution by the ISD unit. So unless all the conditions, so for example, the invoice has not been received, so ISD unit cannot transfer it in the same month, even if it is reflected in 2B. So in nutshell, the reflection of ITC in 2B of the ISD unit is not sufficient to hold that ITC is available for distribution and it should be distributed in the same month in which it is appearing in GSTR 2B. So with that, the High Court held that ITC can be distributed in later month also when the conditions are complied with. So from this judgment, there can be other implication also. But before that, Ayush, you want to add anything on that?
On this judgment only, I think because it is practically not possible to distribute ITC, right? Like the court had rightly said that once the conditions of section 16 will be fulfilled, then only I am, eligible, or that ITC is available for distribution, and then only I can distribute it in that month. Secondly, my question is, how does it matter in which month I distribute it first? Because for ISG, the turnover has to be taken of the previous year, right? And that turnover is not going to change until and unless there is a transition from one year to another year, or one quarter to another quarter. Then yes, you can say that because there are provisions under ISG that if there is any new registration, then you have to take the turnover of the previous quarter. Otherwise, you have to take the turnover of the previous year. Then how does, if my ratio is going to be same and if I distribute it any month, I think mathematically it won't make any difference.
Ayush, so what I understand, this might impact in case the other unit, the recipient unit, has a tax payable in cash in a particular month. So
Hmm.
the company would want to plan it in a way that ITC can be distributed so that they can utilize it. And in the month when ITC is getting accumulated, so they would avoid that.
Yeah, maybe this may be one of the issue, but see, accumulation or the tax planning, when I am delaying the distribution of the credit, ultimately what I am delaying is my accumulation. What I am not delaying is the cash payment. See, suppose I want to distribute it in the month of April when there will be no cash payment. So if I distribute more, there will be more accumulation. So what I foresee is that there will be a cash payment in May. So I will distribute in the month of May. Now for ISG, when that credit is available in my ISG returns in table GST 6, I think in the month of April only, then if I distribute it in May or April, it doesn't make any difference because I have already paid the tax amount to my vendor.
Right.
You see, so I think cash payments, differentiation is not, this is my just point. So,
But largely the issue is about the reconciliation because the month in which it is coming in 2B, I might not be able to reconcile all the invoices,
right.
especially for the petitioner in this case, like a Reliance group. So
Hmm.
that might be one of the challenges.
Right. Right. I mean, apart from this, there are many other challenges in ISG, Gopal. One of the biggest challenge that we are facing right now is that the many clients that ask us is if I book a hotel, if I'm registered in Karnataka, my ISG registration is in Karnataka, and someone from any of the premises of a company, say from anywhere, goes to Delhi or any other state other than Karnataka and books a hotel for day or two in that state and takes the invoice on ISG registration. The hotel will definitely charge CE plus S on it. There is no doubt on it. But if I give my ISG registration of Karnataka, say for booking a hotel in Delhi, so can ISD can take the credit of that ITC and can they distribute that credit as eligible ITC, or whether it has to be distributed as ineligible ITC? So,
So Ayush, I think there are two points on this. One is that normally in case of the normal registration, the department usually denies that if you are registered in West Bengal and if you are paying CGST, SGST, say in Karnataka or in Delhi or in other state, so you are not eligible for the credit. So there are again two viewpoints. One is that at least for the CGST portion, I should be eligible because CGST is a central law. So there is no revenue loss also, and there is no impact also because I am registered under CGST. So in the normal registration, normal regular registration, the this is the issue. If we route it through ISD, this will be like doing something which is otherwise not permissible. So doing something indirectly, which is
Hmm.
directly not permissible. So that might not be allowed. And if we take some hint from this judgment, while this judgment says ITC available for distribution, so whether that means ITC available, now they have said it is to be read as compliance with all the provision of section 16(2). So
Right.
when I am not registered in the in a particular when I and if it is getting the invoice of Delhi CGST SGST, so department can say that when you are not registered in that particular state, you have not complied with section 16(1) itself.
Right.
So this judgment will negatively impact those cases. But going by the wordings of the IGST distribution mechanism, it says that central tax and state tax shall be distributed as IGST accumulation aggregate of CGST and SGST. So going by the plain wordings of the Rule 39, provision of Rule 39, I think it should be allowed. But yes, it's a very gray area. What's your
Right.
view on this?
I mean, same, because when I go by the wordings, read the act, it says rule that IGST can be distributed as C and S can be distributed as I. Now, what I understand from that is that the place of supply is Karnataka, the location of supplier is Karnataka, and then he's charging C plus N on my ISD registration, that I can distributed as I to all the registrations. But when place of supply in itself is different, and when that credit in itself is not allowed under the law due to any reason whatsoever, so I cannot, take a detour or take a, other way around to say that no, I can take this credit. Like once, like you said, that once it cannot be claimed directly, it should not be claimed indirectly. We should not, find out a way out to claim the credit of those hotel invoices.
Right.
Yes.
Ayush, when we are talking about ISD, I have one or two more interesting aspects that the issue that industry is facing regarding the ISD. So there is a provision under the ISD which has now from 2025 ISD provisions have been amended. Now the ISD definition itself in section 2 of CGST Act specifically includes that ISD can distribute the ITC in respect of tax paid under RCM. For
Okay.
that reason, they have amended Rule 39 and inserted Rule Subrule 1A, where they have mentioned, where they have specifically provided a mechanism that in case there is a tax paid under RCM, so the unit which is registered in the same state as that of the ISD state, that particular unit can raise the invoice to the can make the payment under RCM, and for that payment they can issue an invoice to the ISD, which we commonly call as cross charge. So they can cross charge it to ISD, and ISD can further distribute it. So from 2025, this appears that RCM, for the purpose of RCM credit, this route has to be followed. Now, prior to this, also RCM was being paid by the by the unit registered under regular scheme, and they were issuing the invoice to the ISD unit, and they were taking the shelter of there is a rule 54(1)(a), which provides that when the two units are registered in the same state, one is ISD, one is regular, so regular unit can pass on the common credit to the ISD unit.
Right.
Now, even after amendment in Rule 39, that 54 has not been amended. 54 is a general provision which says that the one unit can transfer the credit of common services to the ISD unit, but it does not specifically mention about the RCM only. However, Rule 39 specifically mentions RCM. So going forward, when let's say there is a regular registration, now that unit has taken a common service and it has taken in its own name. Let's say by mistake it has taken the invoice of some XYZ service in its own name. Now they want to route it through ISD because ISD has been made effective from 2025. Now that service is not pertaining to RCM. So can they take a setter of 54(1)(a) and route it through ISD and say because 54(1) allows all the services, or whether department will say ki even though 54(1)(a) allows all the services, 39(1)(a), which is the basically the enabling provision, it provides only RCM to be routed. So what is your take on this?
See, whatever the example you have taken or whatever the query, I'll tell you the most interesting part of it. That why the company, because we have one of the client is doing so, and not only a small portion of the credit, that client is transferring around 60-70 crores a month from normal registration to ISG registration. And why so they are doing it, instead of us repeatedly reminding them that this may create a problem in the future. There are invoices of Google and Facebook which runs their ads on internet and everywhere, and which raise them the invoice on their normal registration charging GST. So there are two type of invoices. First of all, of Google invoice. On one, they do not charge GST and they pay tax under RCM. And secondly, Google and Facebook charge taxes on some invoices. Now they have given their normal registration, and then Google and Facebook has specifically said no to change their normal registration to ISG registration. So when I talk from the company's perspective, they cannot, just because of GST, they cannot stop their services from Google or Facebook because they're not issuing them the invoices on their ISG registration first. Now when this when now this is a challenge, that the common service is being utilized by every unit, the invoice is being the invoice is coming on the normal registration, and then the normal registration is passing on the credit to the ISG registration, and then ISG registration is distributing the credit to everyone. At first instance, this may look like a revenue neutral situation, or that nothing is wrong in this, as the credit is being distributed to all the states. But when I talk simply about law, see, 54, Rule 54 only talks about what are the particulars that are required to be there on the invoice issued by the ISD unit, right? You're on mute, Gopal.
Invoice issued to the ISD unit.
To the ISG, right? Sorry, to the ISG unit. So this is not the provisions of Rule 54 does not govern the distribution of ISG, the manner of ISG, or they are not per se the enabling provisions. They are only saying that whenever the invoice has to be issued to ISG, what all particulars should be there. Now when I talk about pre-amendment, post-amendment in 2025, that Rule 54(1) capital A was always there. Only Rule 39 capital 1A was inserted,
Insert.
and the section 2 definition of ISG was amended, which enabled normal registration to pay tax under RCM and then distribute it through ISG by raising an invoice. But when there is no enabling provision of raising invoice from my own registration to ISG registration for all the common services, I cannot take, you know, a cannot take the shelter under Rule 54(1)(a) and say that since 54(1)(a) says कि distinct person having same PAN and same GSTN code should consider this particulars. But when there is nothing in the act, how can a rule prescribe so? So this may cause a problem. I mean, this is a very gray area, and this may obviously cause a problem to the taxpayers, according to me. I mean, what are your views on this?
So I'm on the same page that as far as this Rule 54(1)(a) is concerned, it is with respect to the content. Even the placing of the provision is under the chapter of invoices and all. But 39(1)(a) is very specific for the ISD. But then there comes a question ki if it is only about the content of invoice to be issued by normal to ISD unit, what about the positions taken before 2025? Because when we go to the history of Rule 54(1)(a), I think it was inserted in 2018.
Right.
And in that particular period, the GST Council meeting agenda, it discusses about the problem that the taxpayers are facing in distributing the RCM credit. So
Hmm.
for the RCM only, 54(1)(a) was inserted. But if we say that 54(1)(a) is not an enabling provision, it is only for the content of the invoice, then prior to 39(1)(a), there was no provision as such which allowed the normal registration to issue an invoice to the ISD unit. So prior to this, if any position has been taken based on 54(1)(a), the same position should continue today also, because law has not changed. In the provision of 39(1)(a) are not superseding the, or are not notwithstanding to 54(1)(a). So this challenge will also be there. And also, even though the definition of ISD has been amended to include the distribution of tax paid under RCM, so, but prior to that, if it was not there, so prior to that, could we distribute RCM credit? If no, then what should have been the position, and how those litigation will come? That will again be interesting to see. And lastly, if there is no provision in the Act, because as per the provision of Act, Section 31 and all the other provisions, the invoice can be raised only in case of underlying supply of goods or service. Now, when 39(1)(a) is saying that for RCM credit or for RCM you raise an invoice to ISD unit, what is the supply that the particular regular registration is providing to ISD unit to raise a cross-charge invoice? Can it be called as invoice without supply? If yes, how is it permitted without any backing in the Act? Can the rule specifically provide which is not provided in the Act?
So second problem that I would like to mention in this, that when I raise one invoice from normal registration to my ISG registration, it is increasing my turnover of the normal registration unit.
Right.
And for the ISG, I take the turnover as a ratio. There is no other criteria and prescribed under the Act. Only I can take the turnover. So if not of this year, but when I go to the next year and distribute the ITC on the basis of the turnover of the previous year, then obviously that main unit will get the more ITC because of this artificial enhancement of turnover, I can say, of enhancement of turnover, because of raising of these cross charge or maybe these invoices to ISG unit and not taking these invoices directly on the ISG unit. So they may get more credit as compared to other units.
Right. So these challenges will be there, and maybe ideal situation would have been if the ISD unit itself had the procedure to make the payment of tax under RCM, then perhaps these issues would have been resolved.
Right. No, when I talk about RCM, there is one more issue that props up in my mind, is regarding that the judgment that you discussed, a beautiful judgment, that when can I say that ITC is available for distribution? Now, when I talk about RCM is paid by the normal GSTIN unit and then it is transferred. So first of all, when do I transfer that RCM credit from a normal GSTIN to the ISG GSTIN? That is in the same month when I am paying the credit, or in the subsequent month when I have already paid the credit. Why I am saying so is, if I have to distribute the credit in the same month, or I have to pass on the RCM ITC in the same month, I will have to file my GSTR1 on 11th of that month, and then ISG will be distributing that credit on 13th of the same month, right? But the tax will be paid on the 20th of that of the month. So tax will be paid later on, but the credit will be distributed before the tax is being paid. So my question is, should I distribute RCM credit only in that month when when the RCM liability has arose, and in the same month when I'm paying it in my GSTR 3B, or I should distribute it in the subsequent month after paying that credit, RCM credit, in my GSTR 3B? I mean, any views on it? You're on mute, Gopal.
This again interesting, the point that you have said, because 11, 13, and 20, these 3 days. Now it might happen that I have raised a cross charge invoice to ISD on 11. On
Hmm.
30th, the ISD unit has distributed. But on 28th, for some reason, either you have not filed your return, you have delayed it. So that will be causing the distribution of ITC, which has not been paid at the first place.
Right.
So for the normal supplier cases, when my supplier doesn't file GSTR 3B or supplier's invoice is not appearing in 2A, these issues are there for the recipient. But this is within the same PAN, within the same entity, these issues are there. So that will be like, because without making payment of tax, I'm not eligible to take the credit because it will be in violation of 16(2)(c).
Correct.
So the third unit which is taking the credit, that is not that credit is not in compliance with 16(2)(c) because the main unit has not paid the tax.
Right.
So again, that will be that is still gray area, and that will also be resolved maybe over the period.
Right. According to me, I think if I only say follow a prudent, conservative approach, then the RCM credit should be distributed in the next month only.
Next month.
Next month
In
only.
fact,
Uh,
if I recall correctly, in 2017,
mhm.
for first few months, even the taxpayers and the when the taxpayers approached the department to get the clarity, department was also of the view for the normal registration that when you are making the payment, we have seen at least 2019 or maybe mid of 2020 that people were following T+1 approach. You are making the
Right.
payment of RCM in 1 month
Correct.
and
Yeah, because that was followed in service tax, right?
service
Earlier.
tax. Right, right,
Yes.
right.
Mhm.
So perhaps that should be the solution here also.
Right.
Yes. So
Okay.
I think we should move to next case,
We'll
Ayush.
move to next case, but if anyone has particular query related to ISG only, then we can take up, or they have any other issues related to ISG only right now for the audience. If they have any issue related to ISG. Okay, then I'll take up the next case. Very interesting case related to section 67, section 74, or the interplay of section 67 and section 74. Karnataka High Court in the case of Vigneshwara Transport Company. To understand this, we need to go into the history first. There were two cases. One, Karnataka High Court single bench in the favor of the assessee, and then the department appealed before the division bench and that case came in the favor of the revenue. What is the case is that a search was being conducted at a unit situated in Bangalore. That search was conducted by the Mangalore GST department, maybe some other department, which were deemed not to be the proper officer or not to be the jurisdictional officer for that Bangalore unit for the assessee. So now what they did was they came to know that assessee raised the point that you are not the proper officer, you are not authorized to search our premises. So whatever the material you have seized or whatever the information that you have gathered is illegal and they cannot be used. What they did was they transferred all that information and all that material, whatever the documents were seized, to the proper officer of that assessee, and that proper officer, on the basis of that information, issued the show cause notice under section 74. Now, what transcribes here is that whether the show cause notice issued under section 74 on the basis of the information received or gathered on the basis of illegal research, I can use the word illegal research, can that show cause notice sustain under the GST law? Very interestingly, single bench high court in this case held that a show cause notice cannot be issued on the basis of borrowed satisfaction. So, what is borrowed satisfaction? The term that they strategically used is that materials gathered from some other party or on the basis of illegal research, because what the Bangalore proper officers did was they issued the show cause notice on the basis of the information whatever they have received from the improper officer. I must use the word improper officer. So what they said was that the search was illegal and hence the show cause notice that is issued on the basis of the documents received from that illegal search is also not valid. Department went to again challenge this judgment of the single bench judgment, the division bench. Interestingly, what division bench held said that section 74 and section 67 are independent of each other. Section 74 again is not withstanding section 63, section 67, or section 67 is not subject to section 74. Only section 67 says that after conducting a search under section 67, a proper officer can issue a show cause notice as per section 73 or section 74. But both these sections are independent and both these sections operate independently. And they both these sections confer substantive power upon the proper officer to initiate adjudicatory proceedings. So again, also High Court in this case relied on the judgment. Basically, in the case of Puranmal versus Director of Inspection, that is the income tax judgment of the 1973. Very landmark judgment in the case of search and seizure. Basically, what was held in that case is that evidences discovered by the search may can be used to issue a show cause notice or to raise any demand, if even if that search is said to be that the evidence is said to be based to be gathered on the basis of some illegal means. But this is only applicable in the case of taxation laws. Relying on this judgment, the department said that whatever that the assessee in this case has not challenged the statements relied upon by the proper officer, the information on the basis of which the show cause notice has been issued by the proper officer. What the assessee in this case is challenging is only the way by which those documents or those statements has been recorded. Since Section 74 is independent of Section 67, therefore, the show cause notice issued under Section 74 is a valid show cause notice. So before discussing, Gopal, do you have anything to say into this?
Ayush, this particular aspect is very interesting. I have been seeing this thing in other laws also. So, if we go in US law, so there is a doctrine of poison, fruits of poisonous tree. That means evidences obtained from illegal source are illegal and inadmissible. But interestingly, the Indian Evidence Act does not specifically cover any such provision, neither the Indian jurisprudence. So, Indian jurisprudence is only focusing on the relevance of the evidences, at least in the tax law. Perhaps in one or two criminal law, I don't remember exactly, but there have been some discussion about this doctrine in India. But it is very, very unsettled as of now whether this doctrine should be applicable or not. But what I see, if we say that 67 and 74 are to be delineated, so in that case, the 67 may not hold any relevance because whenever 67 search and all comes, so the taxpayers and professionals look for the authorization by the proper officer and everything. Now, if the taxpayer and professionals are not checking for whatever reason, if it is missed out, so the officer will conduct the search, and if it is illegal, they will transfer the evidences and documents to the proper officer who will initiate proceeding under 73 or 74. So the purpose of authorization, purpose of legal search will become redundant. This is how I see. And secondly, if these are if these are separate, then all the provision, for instance, the in the case of GST audit. So GST audit says all the discrepancies, all the observations and all have to be informed to the taxpayer, and the proper officer may initiate action under 73, 74, 67, etc. So there also, if in the case of audit, five observations are there, can the notice under 73 go beyond that, those five observation, and raise another issue saying 73 and 74 is uh, it is separate from 65, or it is separate from 61 scrutiny of return. So as of now, once the proceedings under 61 and 65 have started, so there was one view that the same file is being transferred to the executive commissioner, who is then issuing the show cause notice, etc., based on those documents only. Now, if that very audit procedure is not correct, the proper opportunity has not been given. So, if we take hint from this judgment or rely on this precedent, then it would mean that all the proceedings, irrespective of whatever the officer does before show cause notice, so
Hmm.
if the show cause notice is valid, everything else is valid. All the evidence, because I remember there was a passing remark in the case of, or maybe some specific ratio in the case of, in some judgment by the Honorable Supreme Court, where they said that in case of bank attachment, the proper officer, it is the commissioner should be of the opinion. Similarly, the provision of 74 are saying the proper officer is of the opinion. Now, how proper officer has come to that opinion if the search was conducted by some other team who is not authorized to do so? So how my proper officer or the proper officer of my jurisdiction is of the opinion that this tax has not been paid or short paid. So
Yes, read
just
the
by,
slate basically.
sorry,
Yes. Come on. Sorry, Nidra.
so that's the point. Ki how the department will justify or the that it is the proper officer who has obtained this or who is of the opinion just by relying on some other document without applying my own mind. So that is one thing I would point out in this particular judgment or in this particular discussion.
I mean, correct, because see, the very basis of issuing the show cause notice is section 67, right? I remember there are judgments. I specifically remember in the favor, one or two judgments of which High Court, I don't remember, that show cause notice was issued without issuing ASMT 10. So whether that show cause notice is valid or not, and it was held
PepsiCo
to be,
Industries.
yeah,
PepsiCo Industries in Guwahati High Court.
right. I think that was held to be invalid show cause notice.
Invalid because
Invalid
it was scrutiny of return, so it should be preceded by a ASMT 10.
by an ASMT 10. So, but if you read the language of section 73 and section 74, see, I understand that once the search is considered as illegal, the show cause notice based on it should also be considered as illegal, right? But when I talk particularly that section 73 and section 74, again they do not say that show cause notice should be issued on the basis of 61, 65 or 67. 61, 65 or 67 says that you can proceed to 73 or 74. What 73 and 74 says that whether any tax is short paid, not paid, input tax credit wrongly taken, excess taken, a show cause notice can be issued. So can I say that, see, if I see from my returns available on the portal that the department is seeing, and they can clearly see that input tax credit has been excess taken, whatever is appearing in GST or 2B, or that the tax liability is short paid, when there is a difference in 1 versus 3B. Can I say that the department is required to issue ASMT 10 under section 61, or they can directly issue show cause notice under section 73?
So many times when they issue show cause notice directly under 73,
Hmm.
although they issue directly show cause notice, but they mention on the basis of scrutiny of your returns.
Right.
So from that, we can take a stand कि भाई, if you are doing a scrutiny of return, Rule 99 and Section 61 says when the proper officer scrutinizes return, the proper officer may scrutinize, he shall issue an ASMT 10. So if they are not scrutinizing, they are doing on some other basis. Maybe they have some investigation report, some other document. Then they can proceed to 73 or 74 as the case may be. But when they are scrutinizing the return, the provision of Rule 99 specifically says he shall issue an ASMT 10. It is not he may.
Right.
So there also there is
There
this
also is a
impact.
lacuna, I think, again, a gray area again has to be set.
Right.
Right,
But
right,
for this judgment particularly, because otherwise every officer will take a chance that let's do a search. If it is legal, then we'll get the document. If it is illegal, we'll proceed to 73 or 74. So
right.
that
Correct.
will be like trial and
This
error.
judgment should be challenged in Supreme Court and see, let's see what comes out of it.
Right.
I think it's
Anything
12.
else on this? Or
I I can we can open the floor for everyone.
right.
They can start asking their queries. So yes, if anybody has any particular query, they can write in the chat board or they can raise their hand. We can unmute them and
meanwhile, participants are typing their queries. Ayush, I received one query very recently. I would
hmm,
like to discuss it over here for everyone's benefit.
hmm,
So this intermediary provision, now these provisions have been amended, but
right,
I understand it is not yet effective. But
hmm,
everybody is of the view that now it has been amended. So as of now, the situation is the same that we had been facing. When there is an intermediary, it is not an export of service, and when there is a foreign intermediary, it is not an import of service.
correct,
Now, once the law gets amended, and I have, let's say, taken a position prior to the amendment or the prior to effective date of amendment that so this is a practical case that the taxpayer is considering a foreign intermediary as not an import of service and has not been paying the tax. So, but if the law gets amended, it is prospective. But it has been seen in many cases that department tries to apply the provisions retrospectively, asking for the demand on that,
Right.
while denying the refund for the export side.
Right.
So, any input on that? Any particular
Uh,
insight?
no, first of all, when I am clear that is an intermediary service, the provisions that are being omitted, or the intermediary provisions, see, we will have to see what is the effective date of it. That whether they are being omitted respect. See, omission. If you, I have a particular judgment like Rule 9610. If you see, Rule 9610 has been omitted from the law, and it is not written that from which effective date it has been omitted. So, there are the judgments of the various high courts in this Andhra Pradesh, Assam High Court. I remember that in which it is said that once there is no saving clause in this Rule 9610, that once it has been omitted, it has to be considered omitted retrospectively, and any proceedings that is going on, any show cause notice or order that is being issued on the basis of 9610 has to be dealt with as if the 9610 was always not there.
Amended law.
Amended law, yeah, as per the amended law. So now, if the government says that intermediary provisions are being omitted with effect from this date, then I can obviously say that prior to that date, my provisions, my services were falling under the foreign intermediary services, and whatever the taxes that whatever I mean, that was not an import of service, and therefore I have not paid the taxes. Interestingly, the case will become interesting only when the law in itself is being omitted, the provision is being omitted with no given date. Right now, applying the same logic, which the courts have time and again held that omission should be read from retrospective view. So can department go and ask me that from the previous years also you pay me the tax and for the import of services? I mean, that will be very interesting to see. I think uh, if I say apart from the time barring provisions, what are the grounds that you have that you can take to state department that the demand is not sustainable?
Mm, only the time, if it is retrospective, then we can say that there is a doctrine of promissory estoppel also.
Right. Promissory estoppel, right? Hmm.
So I was not aware that government is going to amend the law maybe 7 years, 8 years later, and then I'll have to pay the tax retrospectively. That also with interest,
Right.
because although there is a circular which allows me credit of RCM paid in respect of unregistered inward supplies, that I can take the credit once I make the payment, but the department will tend to cover it in 16(4) and say that I'll not allow you ITC also. So that will be
Right.
like double jeopardizing for me. So I don't think that should sustain. But first, we should obviously wait for the effective date.
Yeah, I mean, yes, that is what we are the judgments on the various judgments on the doctrine of promissory estoppel, that once one thing has been promised and acted upon, you cannot take away and say that whatever the benefits I have taken or accrued from that promise, you cannot take away those benefits from me, right? So this has to be challenged on that basis only, but I believe that omission will be from the basis of prospective date only. There will be no retrospective date. Because if it is retrospective, then why can't I claim the refund? Why can't I say that there was export of services and whatever the taxes that I've paid has to be refunded to me?
Right.
Except from
So
this as where is circular that that their favorite circular, their favorite line, as is where is basis. So
if it comes prospectively, one more interesting thing would be during the transition period. So let's say if the effective date is, for example, 1st of July or 1st of September, if any service has been exported in the month of, or maybe 2 3 days before that transitionary date, and the payment has been received later on, whether that should, how the time of supply provision would come into picture, because Section 14 will play a role, whether it should be considered as a export of service or not in the amended law, or whether the old law should prevail.
see, we will have to see the provisions of Section 14 only. So when the
Right.
service has been completed, when the payment has been received, I think, and these two other criteria.
Invoice.
So, invoice has
तो
been raised.
दोनों, हाँ, दो चीजें जिधर भी फॉल कर रही हैं.
दो चीजें इधर भी fall कर रही हैं, and when the invoice has been raised. So timeline to issue the invoice in case of services is that within 30 days of the completion of the service. Right now, when the service has been completed, when the invoice has been raised, and when the payment has been received, whichever two falls on the whichever date, will have to follow that provisions only for the time of supply. So I think
Right.
that's clear. And if it falls beyond before in the
The
import of services after
subsequent.
amendment, then obviously we'll have to pay tax on it.
Right,
So
right, right. And apart from intermediary, one more question that is currently being the issue currently being faced in the tribunal GST.
hmm,
So the provisions of 112 subsection A, that is pre-deposit,
hmm.
and similarly 107 subsection 6, that is pre-deposit. So there is a proviso that in case of only penalty order, you have to make the payment of 10% of tax, 10% of penalty as a pre-deposit. But this under the CGST law. Now, first appeal mein to everybody was following the amended law, saying that CGST has been amended, so we are making the payment and filing the appeal. But if the now before the tribunal, many appeals are pending which are only pertaining to penalty. But CGST Act has been amended with effect from 1st October 2025, if I remember correctly, and it provides that 10% of penalty as a pre-deposit. But many states are yet to amend their law. So what should be the approach for filing the appeal before the tribunal? Whether they should pay the CGST portion ka pre-deposit and SGST they should not pay because state law has not been amended. Particularly, for example, in West Bengal, as of now, I don't see any public information regarding the amendment. Similarly, other states also many states are yet to amend their law. So how should the taxpayer approach this situation?
Yeah, I mean CGST has to be for I mean CGST has to followed by central tax and SGST through state tax. So if state tax has not been amended, I cannot say that central tax has been amended. So state tax, it is logical that it has to be amended, but once if it is not amended, then I have to follow the provisions of state tax only, whether beneficial to me or not. Right. So if I am saying that CGST has been amended and I'm paying 10% of the tax amount, but at the same time state tax has not been amended, so I will not pay the pre-deposit.
But I think as of now, a portal like the GST
Portals
portal,
don't allow. See, portals are governing the law. Law is not governing the portal. That I say every time.
right?
Ki portal, whatever the portal is the law.
That's why portal ends with L, L से law start हो रहा है.
Right.
Portal is starting with the law.
That is what. Yes.
So
Interesting. One interesting
practically,
case I'll tell Gopal. So sorry to say. One interesting case in
mm,
this I'll tell Gopal that this since after this amendment, what is happening, started happening, especially in Delhi. I dealt with one case, very interesting case, around 1 CR or more than 1 CR crore demand, only tax demand. Show cause notice, one show cause notice was issued under Section 74, and under Section 74 only one show cause notice was issued. I think 1.5 CR something demand was there. We filed reply. There came three orders of it. Now, demand was same. What three orders consisted? One of tax, second of interest, third of penalty.
okay.
So what department did was they broke those three things into different orders, just because after this amendment only, because then when I will file the appeal, I will pay 10% of tax for the first order and 10% of the penalty for the
Correct.
third order. Maybe for interest nothing, but they will get 20% out of the same thing, which only was I was required to pay 10%. And when I filed for the rectification of the order, I had a huge fight with ADC in this case. Then I went to the principal commissioner. I mean, principal commissioner, there is no provision. I mean, they are not able to rectify it. Principal commissioner directed that ADC and all to okay rectify this order, but there is on the portal they are handicapped to rectify this order. So now when I will file the appeal, I will have to pay 20% as pre-deposit. Yes, you were saying something.
नहीं, so this kind of issues, this about the pre-deposit.
Hmm.
But apart from that also, like recently, this handicapped wali thing.
Hmm.
So I got to know about one issue that one particular client is facing. So they were handling their stuffs in-house. Now what happened in 2018-19, a particular demand was raised. regarding the mismatch in GSTR 133, and the amount was debited from their electronic credit ledgers because they did not file the appeal timely and all. That matter got sorted. For 1920, they again received the show cause notice. They did not reply, or they could not reply for whatever reason. They did not file the appeal also. Order got finalized. They did not file appeal. It's been almost 2 years. Now they have received the recovery letter, and now they are seeing on the portal that the demand that is made in 2019-20, it is replica of 18-19. It is mentioning April 18 to March 19, all the differences pertaining to 18-19.
Huh,
And now when the client went to officer and asked for rectification, officer says I cannot rectify beyond 6 months.
huh,
So the client told the officer that as per the proviso, if it's a purely arithmetical error, you can rectify it after 6 months also. The
hmm,
provision clearly says, he says, but application should be within 3 months. So you
hmm,
have to apply within 3 months. I can rectify even after 2 years. But
huh.
since you have not applied for rectification within 3 months, I am not allowed to do so. So this is the problem with the portal, as well as the way this entire thing is system is working.
System is working right. System is working very
Uh,
differently from what the yes.
Right. I used one more query regarding the GST 80. So there is a appeal filing fee for GST 80.
Hmm.
Now CGST law says 5,000 rupees you will have to pay. I'm talking about the minimum fees. So 5,000 you have to pay. Now state laws also have similar provision. Now when I'm making payment to the this tribunal, making payment for this fee, this is going to the GST 80 registrar. It is not going to any state or any
Right.
center.
Hmm.
So whether I'll have to pay, if I have a demand of CGST, SGST, IGST, whether I'll have to pay 5,000 CGST, 5,000 SGST, and for IGST again 10,000, which is the aggregate of both C and S, or whether it should be 5 and IGST also 5, or whether there should be zero payment under IGST, similar to late fee concept.
Yeah, I think there should be the fees that should be paid should be 5,000 CGST. This is the appeal filing fee. See, this is the fee. The fee is not for per tax. This is per act. What I am filing the appeal is under CGST Act and SGST Act and not under the IGST Act. So according to me, the fee should be 5,000 CGST and 5,000 SGST and nothing for the IGST.
Okay. Because there are some views, that's why this creating confusion.
Hmm.
So CGST, SGST are going parallelly. So C and
Right.
S 5,007. IGST Act Section 20 borrows the provision of appeals as it is.
Right.
Now
There, uh, hmm,
it
hmm,
doesn't say that you. So for example, for the pre-deposit, or for the other for pre-deposit, I guess IGST says twice of C or S, something like that. But in the case of in the case of late appeal filing fee, IGST Act is not saying it should be doubled or it should be one time, but it does say appeal provision are to be borrowed mutatis mutandis.
I think there is one query.
Yes, yes.
Ajay Janji, show cause notice and cancellation registration can be same time. Cause of cancellation is non-operation of bank details. Bank was migrated from previous regime when we complain this type of department. Show cause notice and cancellation registration can be same time. See, from what I see from this query, Ajay, is that there has to be a difference between the cancellation of registration and the show cause notice. See, show cause notice is being issued to you to ask the reasons why your registration should not be cancelled. Whatever the delegations that the department may have made, what they can do at most and what they do is they suspend your registration, but they do not cancel your registration. They should give minimum time of 30 days to reply to that show cause notice. Once you furnish a reply to the show cause notice, an order cancelling the registration should be passed, and then only they can cancel the registration. And at the same time, they should also give you a personal hearing before cancelling your registration. So if you are saying that show cause notice and cancellation of registration is of the same date, then I must say that it is a gross violation of principles of natural justice, wherein you have not been given the opportunity to represent your case. That is, you have not been given the opportunity even to file the reply to show cause notice, let alone the personal hearing of that show cause notice. So if the show cause notice date and the cancellation of registration date is the same, you should directly appeal, file a writ petition before the High Court saying that there is a gross violation of the principles of natural justice, and High Court will definitely, remand back this case and will allow your registration to be revoked, cancellation to be revoked. Gopal, you have anything to say in this?
No, I think this is clear violation of national justice if it is on the same date or same time. Unless these are two particular two different issues, like cancellation is for some other reason and show cause notice is under 73 or 74. So Ajay ji can clear that doubt. If it's a show cause notice for cancellation, it has to give you sufficient time, and then only after reply and furnishing of after furnishing of reply and personal hearing, they can cancel it. And regarding the second query, bank details, bank migrated from previous regime. So I this issue was recently being faced by many taxpayers, at least few friends and clients that are based out of Delhi, I know. So they have faced Delhi, Haryana side that bank validation is not bank account details are not getting validated, even though they are active since long. They are an active they are registered taxpayers since long. So bank validation is getting failed. So we'll have to take up with the jurisdictional officers or also take a screenshot and all if it is not getting validated that I have completed all the formalities or if it is from the previous regime. So uh, after 7 years, 8 years, it makes very less sense to say that bank details are not updated.
Hmm. Right.
So I think the only solution to that is to have a discussion with the jurisdictional officer. And if the issue is recurring that bank account validation is getting failed, to generate a ticket and perhaps if it gets resolved.
Right. I think if there are no other queries, then we can wind up the session. Any, so Gopal?
No, from my end, nothing to add. But Ajay sir, if your doubt is, uh, but there are no other.
WP. Gigi, you can unmute yourself and
You can unmute yourself, right?
ये रिट पिटिशन के अलावा और कोई ऑप्शन नहीं है क्या?
Gigi is saying that petition के अलावा कोई और ऑप्शन नहीं है क्या? सर,
डिपार्टमेंट की भाई क्या होता है, 4 4 5 5 दिन तक आदमी आदमी का धंधा सफर कर जाता है।
सर तभी तो अगर आप अपील फाइल करेंगे उसमें ज्यादा टाइम लगेगा, रिट पिटीशन में आपकी जल्दी सुनवाई होगी हाई कोर्ट में।
अरे बस छोटी जगह से आपको हाई कोर्ट में जाना या वहाँ की फीस देना एक छोटे व्यापारी के लिए थोड़ा सा प्रॉब्लम हो जाता है ना।
सर
Ayush,
हाँ,
Ayush, I think the what Ajay sir is saying, if the writ petition is not feasible,
राइट,
he can also explore the online CPgram portal if
online
this
CPgram portal. And one interesting thing that I will say is what followed in one of my client way back in 2019-20 is I marked till PMO office, commissioner, everyone, every senior in the GST department. I wrote one interesting mail keeping everyone in that in the CC, and my issue got resolved in 2 days. And this was related to cancellation of registration only. It was cancelled because the taxpayer was not found at that place, and that was the holiday. So department went for a physical visit on a holiday. The only miscompliance or the non-compliance of the taxpayer was that there was no board at the premises.
नहीं
So
भाई,
हाँ,
जबकि उसके सारे रिटर्न टाइम से जाते हैं, आदमी बिल्कुल कंप्लाइंस है, 7 साल से भी कंप्लाइंस है, वेट के जमाने में भी उसकी 100% कंप्लाइंस है।
सर आप
तो
एक
उसको
प्रिंसिपल कमिश्नर को मेल लिख दो इसमें। आप प्रिंसिपल कमिश्नर के पास चले जाओ जुरिस्डिक्शन ऑफिस के, आपको क्योंकि प्रिंसिपल कमिश्नर से सोल्यूशन मिल जाता है।
अब ये रोज की रामलीला होगी, ये तो मतलब रोज का ही काम हो गया कि कुछ भी कर दो।
सर एक बार आप जैसे प्रिंसिपल कमिश्नर से मिल करके और अगर सीपी ग्राम को भी आप एक्सप्लोर करते हैं बिकॉज सीपी ग्राम में आई थिंक मेनी पीपल गॉट देयर मतलब फेवरेबल रेजोल्यूशन
हाँ,
एटलीस्ट
ये
फॉर दीज काइंड ऑफ केसेस वेयर एवरीथिंग इज जेन्युइन।
छोटे व्यापारियों के लिए के हाई कोर्ट वाला रास्ता इतना आसान नहीं है कि फीसें अच्छी होती है ना वहां पर।
हाँ, नहीं सर, सही बात है। आप ये सीपी ग्राम वाला और ये प्रिंसिपल कमिश्नर वाला
कमिश्नर
अप्रोच फॉलो करो, आपको एक हफ्ते के अंदर तो रेजोल्यूशन मिल जाएगा कुछ ना कुछ, मतलब आपको
नहीं
पता चल जाएगा क्या होने वाला है कि ये लोग सुन रहे
भाई
हैं।
रिजोल्यूशन तो मैं निकाल लूंगा, उसका बैंक अपडेट कर दूंगा, एक आध दिन में चालू करा लूंगा। पर ये चीजें रुके उसके लिए क्या कर सकते हैं?
सर उसके लिए फिर आइडली हम लोगों को मतलब ये तो जॉइंटली कोई रिप्रेजेंटेशन वगैरह करनी चाहिए इस टाइप की। एंड बहुत सारे एसोसिएशन ये सारे रिप्रेजेंटेशंस कर रही हैं आगे।
सही है,
तो
हाँ तो
हरेसमेंट के अगेंस्ट सारे लोग रिप्रेजेंटेशंस कर रहे हैं, सबको पता है हरेसमेंट केवल एक पर्टिकुलर जगह पे नहीं है, ये ऑल ओवर इंडिया सेम काइंड ऑफ हरेसमेंट्स चल रहे हैं।
हाँ तो कोटा टैक्स बार एसोसिएशन से और सी एसोसिएशन से एक रिप्रेजेंटेशन भिजवाया है।
जी।
ठीक है सर, ओके, थैंक यू।
यस सर, यस सर, थैंक यू सर। आयुष, यू कैन रैप अप देन फॉर टुडे।
Okay, okay, okay. Thank you, everyone. Thank you for attending this, I think sixth or seventh,
सिक्स।
sixth weekly session of ALC. We hope you have all enjoyed it, and we'll see you next time. Uh, Thank you, everyone. Thank you, Gopal. Thank you, Ria.
थैंक यू आयुष, थैंक यू एवरीवन।
Thank you.